This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So last night I did a 2-hour live stream with the 4 horsemen of the adpocalypse, me, Nate Brody, Viva Frey, and Kurt Mueller, and we talked about this remarkable opinion or decision from Judge Christina Snyder in the Katy Perry Dark Horse Flame Joyful Noise case. The judge completely overturned the jury. The same judge, same case, same court. Last year, a jury had awarded $2.8 million to Flame for Katy Perry's alleged infringement of Joyful Noise in her piece Dark Horse. With this was the thing with the 8-note descending minor ostinato. If you watched Adam Neely's video, it goes like this. And that was like the entire thing, and there was a little more to the actual ostinato that you can hear if you listen to Katy Perry's song and then listen to Flame's song, or vice versa. But the judge now completely overturned the jury, and instead of making you watch a 2-hour live stream, which I know isn't something everybody wants to do, I thought we could go over the opinion now in shorter form and see what we can make of it. So this is Judge Schneider's decision. Defendant's renewed motion for judgment as a matter of law or for a new trial. We're going to explain that along the way, and that right there is also a reason why the Marvin Gaye, Robin Thicke blurred lines dispute went the way it did. This copyright infringement action concerns the allegation that an 8-note ostinato from defendant's song Dark Horse infringes upon the plaintiff's copyright in the musical composition of the 8-note ostinato in their song Joyful Noise. Following a jury trial, the jury found for the plaintiffs, awarded damages, and the court entered judgment. Now before the court are defendants' renewed motions for judgment as a matter of law or in the alternative for a new trial. Plaintiffs claim that the instrument beat of the ostinato in Joyful Noise is protectable original expression. Remember, plaintiffs is Flame and Joyful Noise. And the defendants had access to and copied that protectable original expression when they composed an allegedly infringing ostinato for their song Dark Horse. The court held a jury trial from July 17th through August 1st. That's a long jury trial. The jury entered verdicts finding defendants, Katy Perry, liable to plaintiffs for copyright infringement and awarding plaintiffs $2.8 million in damages. The court entered judgment in favor of plaintiffs September 11th, 2019. Defendants filed the instant renewed motions for judgment as a matter of law, JMOL, or in the alternative for a new trial. A group of musicologists submitted a Friends of the Court or amicus brief in support of defendants, Katy Perry, motion for renewed judgment or new trial. Having reviewed the trial record, the parties' submissions, and the submissions from Friends of the Court finds and concludes as follows. So what is judgment as a matter of law? It's appropriate when a party has been fully heard on an issue during a jury trial and the court finds that a reasonable jury would not have a legally sufficient evidentiary basis to find for the party on that issue. Let's make a distinction here for you. There's law and there's facts. You remember Joe Friday, Just the Facts, ma'am? Law and facts. Judges decide matters of law, and a matter of fact can be sent to a jury or decided by a judge in a bench trial. In this case, the law operates in a way where we do an extrinsic test, which is an objective test as a matter of law, and then if you pass the objective test, then you need to have a fact-finding mission or fact-finding effort as to whether there's an intrinsic test, whether a reasonable jury could find for a infringement in this case in a jury proceeding or a jury trial. So we got through all of that, and then the judge now has said, wait a second, we should have stopped at the matter of law test and stopped at the extrinsic test, and no reasonable jury could then find that there's a infringement here under the intrinsic test. We're going to get into those two tests, which is why I'm not explaining them right now. It is well settled that the standard for judgment as a matter of law is the same as the summary judgment standard. As long as there is no genuine dispute as to any material fact and the movant is entitled to judgment by law, then judgment as a matter of law is appropriate. The moving party bears the initial burden of identifying the portions of the trial record that demonstrate the facts or absence of facts necessary for one or more essential elements of a claim which the moving party seeks judgment. The court must view the trial evidence in the light most favorable to the non-moving party, so the judge is going to take anything that's got like wiggle room in it and assume that it goes in favor of the other party as much as possible. And if conflicting inferences may be drawn from the facts presented at trial, the case must go to a jury. In entertaining such a motion, the court reviews all evidence in the record. A court may grant a new trial if the jury's verdict is against the clear weight of the evidence. That's on the motion for a new trial section. So, what do we have going on here? To prove copyright infringement, a plaintiff must establish ownership of a valid copyright and copying of constituent elements of the work that are original. That's going to be a really big keyword in this one, is originality. Is that ostinato sufficiently original to warrant copyright protection? I think a lot of people, including Adam Neely, really didn't want it to be sufficiently original to warrant copyright protection, and now the court is saying so. The sole issue at trial concerned the second element, whether defendant's ostinato 2 in Dark Horse infringed upon plaintiff's ostinato 1 in Joyful Noise by copying constituent elements of plaintiff's ostinato that are original. This kind of copying can be proven either A, with direct evidence of copying, or by showing that the defendant had access to the work and the works are substantially similar. So that's access plus substantial similarity is what we're going to be talking about here. The plaintiffs only assert copying pursuant to the latter method of proof, substantial similarity and access. Substantial similarity is determined by a two-part test of extrinsic similarity and intrinsic similarity. The extrinsic test requires that the plaintiff identify concrete elements based on objective criteria that the works are similar. There are two steps. The court identifies the protected elements of plaintiff's work and then determines whether the protected elements are objectively similar to the corresponding elements in the allegedly infringing work. A collection of otherwise unprotected elements may be found eligible for copyright protection under the extrinsic test, but only if those elements are numerous enough and their selection and arrangement original enough that their combination constitutes an original work of authorship. For a plaintiff that seeks to apply this theory of protection to works where there is a narrow range of available creative choices, the defendant's work would necessarily have to be virtually identical to the plaintiff's work in order to be substantially similar. So the judge is saying, citing the Skidmore v. Led Zeppelin case, that the works would have to be virtually identical under the law and in music, because there's a narrow range of available creative choices. 12 notes in a chromatic scale, only so many notes and chords and chord progressions available for artists to choose from. Only so many colors on their palette. The Ninth Circuit has at times described this result as the work having a thin copyright. So not Robin Thicke, but rather Robin Thin. Infringement claims involving a combination of individually unprotected music elements are subject to this analysis only after the extrinsic test is satisfied. Does a fact finder, a jury in this case, reach and apply the intrinsic test? This test raises a question of fact and asks, the intrinsic test, whether the ordinary reasonable person would find the total concept and feel of the works to be substantially similar. A plaintiff that proves substantial similarity must still prove access. Proof of access requires an opportunity to view or copy, so this is hear, or copy plaintiff's work. To prove access, a plaintiff must show a reasonable possibility, not merely a bare possibility, that the alleged infringer had the chance to view the protected work. Where there is no evidence of direct access, circumstantial evidence can be used. Plaintiffs, Flame here, argue only that the latter circumstantial type of access happened here. Defendants argue that plaintiff failed to establish substantial similarity. The extrinsic test requires the court to determine whether any elements of the ostinato and joyful noise are protected and objectively similar to corresponding and allegedly infringing elements of Dark Horse. The test is critical because copyright law does not forbid all copying, only illicit copying of protected works. If plaintiffs cannot satisfy the extrinsic test for any reason, the inquiry ends, and defendants will be entitled to judgment as a matter of law. The initial query is whether any elements of the ostinato and joyful noise are individually protected, and if not, whether the unprotectable elements that make up the ostinato, taken in combination, are nevertheless entitled to copyright protection. Although there is generally a low bar for originality in copyright, given the limited number of notes and chords available to composers, and because common themes frequently reappear in various compositions, many, if not most, of the elements that appear in popular music are not individually protectable. Music, perhaps more than any other work of art, borrows and must necessarily borrow and use much which was well known and used before. For this reason, courts in musical copyright cases have a significant obligation to strike a balance between the First Amendment and the Copyright Act to encourage others to build freely upon the ideas and information conveyed by a work, and at the same time motivate creative activity by carefully limiting the scope of copyright protection to truly original expression only. Musical elements that are common or trite, such as the use of a long, short, long rhythm, chord progressions, certain tempos, a recurring vocal phrase, repeating hook phrases, the alternating emphasis of strong and weak beats, syncopation, the use of tritones, or the use of basic musical devices in different manners are not accordingly protectable. Nor are other elements ubiquitous in popular music like rhymes, glissandos, chants, the use of horns, or jingling or pulsing synthesizer elements. None of that's entitled to protection. These building blocks, like Legos, belong in the public domain and cannot be exclusively appropriated by any particular author. That's from the Led Zeppelin case. At trial, plaintiffs presented the expert testimony of musicologist Dr. Todd Decker that there are 5 or 6 protectable elements in the joyful noise ostinato which defendants allegedly copied. The length is similar, 8 notes, the rhythm is similar, the melodic content, the scale degrees present, the melodic shape, so the way the melody moves through the musical space, similar, the timbre or quality and color of the sound is similar, and the use of the placement of this material, this ostinato, in the musical space of the recording in the mix, that is also similar. So that's 5 or 6 points of similarity between the two ostinatos. And this is plaintiffs, this is Flame, Joyful Noise, this is their musicologist, Dr. Todd Decker. In their opposition papers, plaintiffs, again Flame, claim that these are actually 9 separate elements. The melody in a minor mode, a phrase of 8 notes, the pitch sequence 3-3-3-3-2-2, a similar resolution to both phrases, a rhythm of 8 notes, a square and even rhythm, the structural use of the phrase as an ostinato, the timbre of the instrumentation, the empty and sparse texture of the composition, so the staccato, I guess. Amici, or friends of the court, musicologists, meanwhile contend that Decker's testimony at most identifies 5 protected elements: the pitch sequence, 3-3-3-3-2-2, the temporal spacing of the notes, the timbre, the purported phrase length of 8 notes, and the placement of the ostinato in the mix. Defendants argue that whether these elements are 5, 6, or 9, none of them can be individually accorded copyright protection as a matter of law. Again, not a matter of fact, but a matter of law. The court agrees that the uncontroverted evidence points to only one conclusion, that none of these individual elements are individually protectable. It is plaintiffs' burden to establish the protected elements of their allegedly infringing work. Dr. Decker did not provide testimony that each of the elements he identified are individually original. To the contrary, he testified that no one single element caused him to determine that the works contained protected features that were substantially similar. Any Single one of these elements would not have been enough, he conceded. It's the combination of them that supported his conclusion. So we're really only talking about the combination of these individually unprotected elements. The clear, indeed only, implication of Dr. Decker's testimony is that if the two ostinatos are similar at all, it is reasonable only as a result of the arrangement of these elements within those ostinatos. Plaintiff's burden to present evidence that establishes the protectability of each individual element is not met when their own expert provides testimony that assumes the opposite. Further, Dr. Decker conceded in substance that several of the allegedly infringing individual elements of plaintiff's ostinato are not original. With respect to the phrase length of 8 notes, Dr. Decker testified that it is characteristic for a phrase like this ostinato to last for 8 beats. With respect to the beginning pitch sequence of 3-3-3-3-2-2, Dr. Decker testified that a repeating scale degree of 3 that later resolves is a technique used for building up tension that wants to be released, and that when such tension is released in a song with a strong beat like Joyful Noise, it is released to a 2. With respect to the way the Joyful Noise ostinato resolves from 3 to 2 to 1, Dr. Decker testified that the scale degrees have tendencies in popular music to make a pleasant consonant sound. 3 wants to go down to 2, and 2 desperately wants to become 1 because 1 is our home note, which indicates that the way the ostinato resolves is not so much original as it is necessity. With respect to the Joyful Noise ostinato's square and even rhythm, Dr. Decker testified that this is a relatively simple rhythmic choice and agreed that no composer is entitled to monopolize the rhythm of 8 even quarter notes. In other words, they're on the beat. There's nothing special about it. With respect to the ostinato's pingy synthesized timbre, Dr. Decker testified that it is essentially common since it would be very difficult to monopolize. And with respect to the deployment of these phrases as an ostinato as opposed to some other musical device, Dr. Decker testified that the ostinatos are commonly used musical devices in countless musical oppositions. In fact, the 9 elements that the plaintiffs identify are precisely the kinds of commonplace elements that courts have routinely denied copyright protection. For the foregoing reasons, the court cannot conclude, pursuant to the extrinsic test, that any of the allegedly original individual elements of the Joyful Noise ostinato are independently protectable as a matter of law. So the court's now going to go on to a combination or a selection and arrangement. The court's inquiry does not end here. Plaintiffs may still prove infringement of their ostinato if they can demonstrate that it is comprised of a protectable combination of otherwise unprotectable elements. Those elements must be numerous enough, and their selection and arrangement original enough to warrant protection as an original work of authorship. Since a selection and arrangement copyright protects the particular way in which the artistic elements form a coherent pattern, synthesis, or design, it is not enough to assert a combination of unprotectable elements without explaining how these elements are particularly selected and arranged. To determine whether the various compositional elements of plaintiff's ostinato are entitled to this sort of copyright protection, the court must review the relevant precedents. And you're going to learn something here, I swear. In Three Boys case, the Ninth Circuit affirmed a finding of copyright protection based on the combination of 5 otherwise unprotectable elements: the title hook phrase, including lyric, rhythm, and pitch, the shifted cadence, the instrumental figures, the verse-chorus relationship, and the fade ending. This was the case concerning whether Michael Bolton's 1991 song, Love is a Wonderful Thing, in its entirety infringed upon the Isley Brothers' 1954 song of the same name in its entirety. After a trial in which Bolton's defense expert conceded that he had not found the combination of unprotectable elements in the Isley Brothers song in any prior compositions, the jury entered a verdict that found infringement based on a unique compilation of those elements. So that was an entire song, not just an 8-note phrase. In Swirsky, the Ninth Circuit considered whether the first measure of the chorus in plaintiff's song, one of those love songs allegedly infringed by defendant Mariah Carey's song, Thank God I Found You, did not constitute original expression as a matter of law. She contended, in part, that the allegedly infringed 7-note first measure of plaintiff's song lacked protection because of its brevity. The Ninth Circuit rejected this argument, explaining that while a single musical note would be too small a unit to attract copyright protection, so kind of your Planck length for copyright protection for music, an arrangement of a limited number of notes can garner copyright protection. The court held that it cannot be said as a matter of law that 7 notes is too short or too small a length to garner copyright protection. So 7 notes can be copyright protected. In Williams, the court embraced and applied the principle that a combination of elements, portions of 6 musical elements, signature phrases, hooks, bass lines, keyboard chords, harmonic structures, and vocal melodies may receive copyright protection if sufficiently original. At trial, the court found that the combination of these elements of Marvin Gaye's song, Got to Give It Up, was protected, and that Robin Thicke parties infringed on the protected elements. The jury returned a verdict for Marvin Gaye and awarded damages. Critically, the Robin Thicke party failed to make a Rule 50A motion for a judgment as a matter of law at trial, which then precluded consideration of a Rule 50B motion for judgment as a matter of law following trial. Accordingly, the Ninth Circuit's review of the jury's finding of a protected combination was confined to the fact-bound, highly deferential review, as in appeals review, that did not permit the appeals panel to revisit the protectability issue, even if it is able to determine a substantial similarity or lack thereof under the extrinsic test as a matter of law. What the heck does that just mean? That was a really big reveal. That means the Marvin Gaye, Robin Thicke, Blurred Lines case, I think it was, that everybody thought the court got wrong. It was actually procedural error on the part of defendants for not bringing a judgment as a matter of law motion before trial and then a renewed motion for judgment as a matter of law after trial. That's what you have to do. You can't bring the renewed motion after trial unless you also bring a judgment for as a matter of law motion before trial. It's a part of the Federal Rules of Civil Procedure 50A and B. So that's why the case was found the way it was because you can't overturn the jury's verdict on a judgment as a matter of law motion because there wasn't one brought. Although neither the district court nor the Ninth Circuit, for this reason, had the opportunity to consider the question of protectability as a matter of law after all the evidence had been presented in the Marvin Gaye Robin Thicke case, the court's conclusion that the jury could have found the 6 individual unprotectable music elements identified at trial cumulatively protectable is informative. A court in the District of Oregon squarely found a protectable combination of otherwise unprotectable music elements in Erickson v. Blake. This is the pi case. This case involved 2 musical compositions that transposed the digits of pi, 3.14159, as a set of musical notes deployed as a motif. The plaintiff alleged that the defendant's composition infringed in its entirety upon the plaintiff's composition in its entirety. The defendant moved to dismiss the complaint pursuant to the extrinsic test on grounds that the works lacked any similarity beyond the unprotectable idea of putting digits of pi into music. The court agreed that pi is a non-copyrightable fact and that transcription of pi to music is a non-copyrightable idea, but did not end its analysis there. After filtering out those unprotectable elements of the allegedly infringed composition's primary motif, the court considered whether the composition's remaining pattern of other musical elements, the choice of scale, rhythm, harmony, and embellishments or variation, whether that comprised a combination of elements protectable. The court concluded that they did. The copyrightability of the song is not the melody based on pi, but the fitting together of the sequence with other melodious phrases into a unique composition. It identified the cadence, flourishes, harmonies, structure of the remaining composition in particular to conclude that the plaintiff had a thin copyright in the song as a whole that protects his work from virtually identical copying in music. Other courts have declined to find similar combinations of musical elements. In Stefani, which I'm assuming means Gwen Stefani, a court in this district considered whether the distinctive pronunciation and rhyming use of a particular lyric at a particular beat, rhythm, recurring vocal phrase, and the presence of tritones qualified the plaintiff's song for copyright protection by virtue of their arrangement in an original matter. The court concluded that these features were not voluminous enough to provide the quantum of originality needed to merit copyright protection and entered judgment for defendant as a matter of law. Same as the thing here. Similarly, in Cottrell v. Spears, plaintiffs alleged that Britney Spears' What You See Is What You Get infringed upon the following compositional elements of their song, What You See Is What You Get. 2 identical pitches at the opening of each song's chorus, 2 verses that begin and end with an A minor chord, the repetition of a particular note 3 times in their verses, and the setting in a 4/4 time. Sounds weak to me. After concluding that none of these elements was individually protectable, the court cited the Ninth Circuit standard and considered whether a combination of the unprotectable elements in the plaintiff's song may nevertheless qualify for copyright protection. The court then cited to a Ninth Circuit decision in Sadava for the rule that those elements must still be numerous enough and their selection and arrangement original enough to warrant protection, and concluded that the same cannot be said of the elements here, especially in light of the fact that they are common to music of this type. On that basis, the court granted Spears judgment as a matter of law. In view of these decisions, the court now turns to whether the musical elements that comprise the 8-note ostinato in Joyful Noise, Reminder, or there were 2. The court concludes that they were not. Although Swirsky contemplates the possibility that an 8-note musical phrase may be entitled to copyright protection pursuant to Sadava, the parties have not cited any authority, let alone binding authority, holding that an otherwise unprotected musical phrase isolated from the rest of the musical composition in fact warranted copyright protection. It is undisputed in this case, even viewing the evidence in the light most favorable to plaintiffs, that the signature elements of the 8-note ostinato in Joyful Noise, the 3-3-3-3-2-2 pitch sequence, the resolution of that sequence with a 3-2-1-5 sequence, the even rhythm without syncopation, and its development across a sparse texture is not a particularly unique or rare combination, even in its deployment as an ostinato. Prior compositions, including prior works composed by these parties, as well as what all agree is a separate non-infringing ostinato in Dark Horse, ostinato 1, all contain similar elements. The unrebutted testimony of defendant's expert, Dr. Ferreira, discussed the presence of this pitch sequence in an even rhythm in the children's songs Merrily We Roll Along and Jolly Old St. Nicholas. The unrebutted testimony of Dr. Ferreira that 3 other songs, including a song composed by defendant Gottwald called Love Me or Hate Me, contained the same evenly spaced repeating pitch sequence with the same 3-2-1-5 resolution, including as an ostinato, and the testimony that the melodic contour of the pitches in the allegedly infringing ostinato Dark Horse and another ostinato in Dark Horse that the music is not infringing. The other elements present in plaintiff's 8-note ostinato also do not bring the combination within the ambit of copyright law's protection. The placement of the ostinato within the composition's verses does not make it so exceptionally original as to warrant protection. That effectively leaves the pingy synthesizer sound, which, even if considered a function of composition, would not transform the Joyful Noise ostinato into protected expression. Synthesized timbre is, as mentioned above, a common element in contemporary popular music. A relatively common 8-note combination of unprotected elements that happens to be played in a timbre common to the particular genre of music cannot be so original as to warrant copyright protection. Because the sole musical phrase that plaintiffs claim infringement upon is not protectable expression, the extrinsic test is not satisfied, and plaintiff's infringement claim, even with the evidence construed in plaintiff's favor, fails as a matter of law. Defendants are therefore entitled to judgment as a matter of law on plaintiff's copyright infringement claim. Conditionally, in the alternative, the defendants are entitled to a new trial because, for the same reason, the jury's verdict is against the clear weight of evidence. Even if the 8-note ostinato were protected expression as a combination, defendants would still be entitled to judgment as a matter of law, since the evidence submitted at trial did not support a legal conclusion that the 2 ostinatos objectively are substantially similar. A selection and arrangement copyright is infringed only where the works share, in substantial amounts, the same combination of unprotectable elements. Here, because the range of protectable expression in an 8-note 8-note pop music ostinato comprised of individually unoriginal elements is narrow, the combination of unprotectable elements would necessarily have to be virtually identical to their counterparts in plaintiff's ostinato in order to be substantially similar. While virtual identity is not the same as absolute identity, the existence of greater distinctions do not negate liability. For example, the Erickson court found no infringement where the cadence, flourishes, harmonies, and structure, among other elements of defendant's song, were not virtually identical or even particularly similar to plaintiff's thinly protected musical composition. The evidence in this case does not support a conclusion that the relevant ostinatos in Dark Horse and Joyful Noise are virtually identical. There are a number of undisputed objective distinctions that, as a matter of law, negate copyright infringement liability. First, Dr. Decker testified that the pitches on the 7th and 8th beats of the Joyful Noise ostinato are different from the pitches in the corresponding beats of the Dark Horse ostinato. Let me see if I can play it for you. So I think it went like this. I think the flame joyful noise went like this. And then Katy Perry's ostinato went like this. I think that's how it went. In Joyful Noise, the pitch sequence of these beats resolves up from B to A, F, while in Dark Horse, the pitch sequence on these beats resolves down from A to E. The fact that the two 8-note ostinatos resolve using two different pitches, despite a tendency to resolve only within a narrow range of pitches, indicates an objective distinction rather than a similarity. The composition of the ostinato in Joyful Noise contains at least 6 instances of portamento, a slide between musical notes, not present in Dark Horse. Dr. Decker acknowledged that the presence of slides in the composition for Joyful Noise is a difference between the compositions. And third, Dr. Decker acknowledged that the compositions for the ostinatos use different keys, tempos, harmonies, and rhythm. Taken together, these objective distinctions are substantial enough to preclude a determination of virtual identity. Even if the Joyful Noise ostinato were entitled to combination copyright protection in the aggregate, and the court concludes that it is not, the court concludes that defendants would still be entitled to judgment as a matter of law. In the alternative, and the judge is setting up for appeal here, defendants are also entitled to a new trial on this basis because, for the same reasons set forth above, the jury's verdict is against the clear weight of the evidence. And then the judge disposes of the intrinsic test too. Although some district courts have determined that the intrinsic test can be resolved as a matter of law, where no reasonable person could confuse the subject composition's overall concept and feel, the court declines to do so here. Even though the court concludes that plaintiff's ostinato is neither protected nor virtually identical to the allegedly infringing ostinato in Dark Horse, a reasonable jury could nevertheless conclude, and did, conclude that the concept and feel of the two ostinatos in this case are intrinsically similar. As to access, the court simply concludes that a reasonable jury could have concluded that the evidence in this case, that the relevant defendants who composed the allegedly infringing ostinato in Dark Horse had reasonable opportunity to have encountered Joyful Noise. I believe it had something to do with them being experienced music writers. The court concludes that defendants' motion for judgment as a matter of law is granted, and the jury's verdict as to liability and damages are vacated because plaintiffs failed to satisfy the extrinsic test. Defendant's motion for a new trial is denied as moot. Plaintiff's motion for prejudgment interest is denied as moot, as are any other objections. The court conditionally grants a new trial for the same reasons set forth above, because the jury's findings on the extrinsic test and damages are against the clear weight of the evidence. So if the Ninth Circuit Court of Appeals remands this for a further proceedings, then the further proceedings will be a new trial. It is so ordered, says Judge Snyder. So that's how we got here, and that even explains the Marvin Gaye, Robin Thicke ruling. So really interesting. I'm gonna stop here because we're already 30 some minutes into this. Thank you very much for joining me. I'm Leonard French, your favorite copyright attorney. Please consider supporting our efforts to bring you these law news and copyright stories and things on patreon.com/ljfrench and sponsors.com/law. Thank you to our $50 plus supporters who get shoutouts by name at the end of these videos. In the month of March, Wes Delj, Aspernari, Video Remonetized, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Blackleaf, Joe Tyson, Benjamin Hitov, Stephen Ottah, Cute Grills in Your Area, Longreach Jones, Zachary Chaney, Mullen PC, and Anders Thorenfeldt. Thank you so much for your support. Thank you to the $5 plus supporters who are scrolling on the screen and on the LED panel behind. Oh shit. That are scrolling on the screen in front of me. And I'm Leonard French, your favorite copyright attorney. I'll see you in the next one, which should be the Led Zeppelin case. Plus, we've got some other weird cases where Broadcom is suing Netflix and where a manufacturer of medical things is suing somebody who's trying to help the current situation that we can't talk about on YouTube. Anyway, love you all. Have some dog video. I'll see you later. Bye. But then we have this Marvin Gaye, Robin Thicke case where there was this sort of where there was infringement, even though they just skip that part.